Hello and welcome to Legal Basics with Sarah Law Global, and my name is Sian. Still on the Employment Law series, today we're going to discuss redundancy. And with me is one of my colleagues, a person that I really respect in terms of legal content, and I will let him introduce himself.
Thank you, Sian. Hello, viewers. My name is Mugambi Mutua. I'm an advocate of the High Court of Kenya. I practice with the law firm of Hamilton, Harrison and Matthews, Coast Branch, that is in Mombasa. It's a pleasure to be here, and I hope we'll have a meaningful discussion on the issue at hand.
Sure. So my colleague from the coast, he may say redundancy at some point, forgive him. Yeah. But can you just explain to our viewers what is a redundancy?
Thanks, Sian. I don't think whether there's a coastal accent on English terms. Nonetheless, redundancy is it means the termination of an employment through no fault of an employee. That is the basic and straightforward definition of redundancy. Other terms that can be used in the place of redundancy are things like layoffs or retrenchment. So it appears that an employee would like to continue working, but through no fault of his own, he cannot continue working, and so an employer is forced to let the employee go. That's what we call redundancy.
All right.
And some of the things that can contribute to redundancy include maybe loss of business, or maybe what the employee used to do is no longer available.
Okay.
Yes.
So in these very unique times during the COVID pandemic, unless you work at Amazon, most businesses have dipped, right? In almost all the industries, they don't have the same business they used to have 1 year ago. So most businesses are looking at having to lay off some of their workforce, and it is important for them to understand how to do it, because I believe there's some value in the process. Maybe you can take us through the process of doing a redundancy.
Thank you so much. Indeed, the times that we're living in are unprecedented.
Sure.
There's a global pandemic that has taken a toll on most businesses. Most businesses have been forced to close. Some of the income that you used to get is no longer available. So this is a locus classicus case, or maybe I can say a perfect example of how employers have been forced to lay off their workers. But in as much as we acknowledge the strange times that we're living in, the law has not been thrown out of the window.
Sure.
The law must still nonetheless be followed. So as an employer, because this process is basically employer initiated and driven, the employee more or less has no say. But we'll see where the employee's say comes in later on. So the employer, what do you need to know? So first, if a redundancy situation presents itself, the first thing to do is to notify the labor office and the employer. You write a notice to the labor office, informing him or informing the labor office that we have this situation and we have been forced or will be forced to lay off a number of our employees. After you do that, you need to inform also your employees that we are in this situation and sadly we'll have to let some of you go. And after you do that, I would propose that there should be an engagement with the employees to prepare them also for the process that is to start. The notice should run for a minimum of 30 days. And during this period of time, there should be now these consultations with the employee to agree on the modalities of going forward. Also to mention, apart from sending the notice to the labor office and to the employee, in case there is a union that is involved, or in case the employee or your employees are members of a particular union, you also need to notify the union. So this 30 days period is for you to engage all the relevant stakeholders to decide on the way forward.
All right.
Yes.
So now, if an employer is in a very tight place, they feel, I can't have these people here next month. What will I pay them with? And they're tempted to just take a shortcut and say, don't come on Monday. We don't have anything for you. What is this employer looking at in terms of the law? What will the law do to such an employer?
Okay. Now, before we get to that, Sian, allow me to first of all address some other issues that happen in between. The redundancy process does not end with the 30 days notice to the employer or to the labor office and to the employees. Remember, this 30 days, as we have said, is to give you a time period for you to engage or the relevant stakeholders to decide on the way to go forward. You need to inform your employees why are you declaring this redundancy situation. Is it their office? Is it their position that has become unavailable? Or is it work that is no longer available? Now, you also need to agree on the criteria of laying off the employees. There are particular, rules that should guide. For instance, if you have a huge workforce, there is a principle of first in, last out. So the first employee that you employed should be the last employee to go out. You need to inform your employees what factors will inform you declaring them redundant so that they know. And in my view, during this process, when you are informing your employees that this is the scenario that we're facing, your employees, if they see that this situation indeed requires all of us to be sympathetic and to be agreeable, can decide to just resign on themselves or to leave voluntarily. Now, if you do not adhere to the minimum requirements, that is, if you do not give the 30 days notice, you do not inform the employee the criteria, and after the 30 days notice, and after you have selected the employees that you need to lay off, you need to give them now a notice of termination. So remember, there's the first notice that we are declaring a redundancy situation, and then there's the next notice that these are the people that we are
terminating.
Terminating. You should also factor in or allow your employees to challenge your selection. Give them the avenue to say, wait, I think I should not be in this pool, or why should I be in this pool? And perhaps this other person is not in this pool. You need to give them that, let's say, freedom, so that you can address all the issues or all the conflicts that should arise. Now, if you do not, now going back to your question, if you do not follow the minimum requirements for a redundancy, your employees have recourse in the justice system. I believe during the course of this series, we have tackled how you can approach a court of law. Now, you will be looking at unfair termination. Yes, that's what we'll be looking at. And remember, we said the rights or the remedies of an employee where their contract of employment has been terminated unfairly is 1 month's notice and compensation of equivalent 12 months. Now, also going back to redundancy, if it has been done correctly, you had to pay your employees something we call a severance package. Maybe at this point we should distinguish. There's a difference between severance package and service pay. So severance pay applies strictly where the redundancy process has been conducted in a very, let's say, in the required manner. Service pay applies where termination has not been as per the required requirements, and where the employee or the employer was not paying the employee NSSF. So that is the distinction. Severance you can agree on the number of days that you're going to pay an employer, an employee, let's say for instance, 18 days for every year worked. So that is the severance package you're looking at, and together with any outstanding terminal dues.
All right. So is there a minimum that an employer can pay an employee upon declaring them redundant?
The severance package, I would say, is the minimum.
Okay.
If you do not pay your employees the severance package, then you'll have dismissed them or you'd have terminated them unfairly. So the severance package, let's say, is the bare minimum when it comes to redundancy. So you can agree on 18 days for every year worked. I think reasonably should not be less than 15 days for every year worked. But yet again, remember, you during the process of consultation between all the relevant stakeholders and depending on the situation at hand, I do not think whether the law precludes parties from agreeing
otherwise.
Yes, from agreeing otherwise. So if the termination is done in a very cordial and reasonable manner, there should be no issues.
Sure.
Yes.
All right. Thank you, Mr. Mugambi, for coming and explaining this concept to us.
My pleasure.
And thank you, viewer, for watching, tuning in. If the viewer would like to reach you, how for inquiries, just to expound on this topic that we've discussed today, how would you be reached?
Thank you, Sen. I would recommend my personal email address, that is titusmugambimutua@gmail.com. Any queries to that email will be answered, and then we can take the relationship from there to the next level.
Sure. So thank you for tuning in. If you have any queries for us, please write to us at info@cyroglobal.com. info@cyroglobal.com. You can also write to us through our Gmail address, which is cyrologlobal@gmail.com. Before we close this broadcast, we'd like to say thank you to Chikiti and Chikiti Advocates for facilitating the shooting of this series, and to Mushiri Frames, who are the videography crew. Both emails will be provided in this broadcast. Take care of yourselves. Bye-bye.